Welcome to the Search and Seizure Overview PowerPoint video for CJC 390. This is actually not in our textbook, so it's a good idea to watch this video to familiarize yourself with search and seizure. The reason why this is included is because the best start to any crime scene is to assure that you are there lawfully and seizing evidence that will be useful in court. If you seize evidence that is not according to the law, that evidence may not be used in court, which makes it really invalid, as we'll discuss here. The objectives that we'll cover in this PowerPoint, we'll talk about the exclusionary rule, the fruit of the poisonous tree doctrine, the Fourth Amendment, and how it governs search and seizure. We'll talk about probable cause and different exceptions to search warrants. Quote from John Adams talked about the Constitution, and an opposing view from Will Rogers. Regardless of what one thinks of the Constitution, it is something that is very important to law enforcement and to criminal justice because it governs how we act and behave according to investigating crimes and scenes. First of all, we're going to talk about the exclusionary rule. Essentially, this is a rule that was set forth by case law, so it is not something necessarily that was in the Constitution, but the Supreme Court, through a series of cases, came up with the exclusionary rule, which essentially says that any evidence that is not obtained according to the law or essentially illegally cannot be legally admitted. Believe it or not, there was a time till the early 20th century that even illegally obtained evidence could be used against an individual, which makes you wonder what's the use of the Constitution. But through case law again, in the 20th century, that was reversed. A joke about lawyers. What kind of stemmed from that too, extending it a little bit further, is the fruit of the poisonous tree doctrine, an interesting doctrine which says that evidence that is obtained illegally can't lead to other evidence that is legal. So essentially, if you find something illegally and it leads to the obtaining of other evidence that is legal, it is still not valid. So that original tree is poisoned. The fruit of that tree is not good either. We'll break down the Fourth Amendment here. Here it is in its entirety, and we'll take little sections of the Fourth Amendment and describe what they are in this PowerPoint in the slides to come. But this is it in its entirety. The first section says what it covers. So it talks about the right of people, so we're talking about people, of course, to be secure in their persons, so that means their individual bodies. So this might apply, for instance, to blood evidence. You can't obtain blood evidence without a warrant or some sort of carefully worded exception. Their houses, so the same thing, you can't intrude into people's houses, or what they say, a person's home is their castle. Their papers and their effects. So in these days, when we're talking about computers and smartphones and things of that nature, that would apply to effects. So the Supreme Court is determining we can't intrude into those things without what follows. And here's what it talks about. It actually applies a standard to searches, and the very important thing is that in certain cases the court has found some searches to be reasonable, but for the most part it says it's protecting you from unreasonable searches and seizures from the government. At the time, policing wasn't what it is today, but the government was still seen as somebody who can intrude into your affairs. Today, this really applies mostly to police departments. And, of course, the big question that you have to answer is the search reasonable? And you see here they are establishing the standard, our forefathers in the Constitution and in the Bill of Rights, of what is needed in order to do a search. So they recognized there should be some instances where you have to do a search, where you have to intrude into someone's home. But they say in order to do so, you need a warrant. You need to get what's called a warrant. And they also say that that warrant should be based upon what they call probable cause, which is something that they didn't clearly define, but over time has been defined pretty clearly through cases. This is really how it is defined. It's where facts and circumstances that are trustworthy, so they have to be correct facts and circumstances, are sufficient to justify a reasonable person. And of course, you see there's a lot of gray area here. What you determine as reasonable may be different from what I determine as reasonable. Really, what counts is what the court determines to be reasonable. So anyway, if somebody has good facts and circumstances, they're reasonably trustworthy, and these facts and circumstances are sufficient to justify a man of reasonable caution or prudence in the belief that a crime has or is being committed. So essentially, a reasonable person believes there's enough information to believe there's a crime being committed that needs to be investigated further. You can find out more in Draper versus United States in 1959. So we took a little departure there, talked about probable cause, and let's return back to the Fourth Amendment, and we're now talking about warrants. Warrants, what is required in a warrant. The warrant has to be supported by someone who's swearing to it. So you see in this picture here, somebody who by oath or affirmation, and particularly describing the place to be searched. So what they're saying now is the warrant has to be sworn to, and also it has to give specifics on what is to be searched. So if you're talking about a house, they even say you need to go beyond the address. So you can't just say 123 North Main Street. You have to actually describe the house. So if you look at a search warrant, it will say the address, but it will go further and usually say things like a white house with a wood roof, red shutters, the third house north of First Street on Main, something to that effect, on the east side of the road. So it really describes it in detail. And the persons or things to be seized. So you have to also say in your warrants not just what you want to search, but what you're looking for. So perhaps you're looking for crack cocaine, or the instruments used to manufacture and package and distribute cocaine. If you stumble across a firearm in the search, that's a different thing. You probably can seize it, but you still have to say what you're looking for in the first place when you give your description in your search warrant. Okay, the important thing to remember, and I would remember this for purposes of potential testing later on, search warrants can only be authorized by a judge. No one else can authorize a search warrant. These are the only folks who can do it. Your prosecutor might look at a search warrant to make sure they think it has all the elements of probable cause in it. Okay, so we've gone through the fact that law enforcement needs a search warrant in order to do a search. But, and there's a big but here, the courts have found that there are some exceptions to requiring a search warrant. And they have basically determined that these are reasonable exceptions. So if you go way back to the beginning of our discussion of the Fourth Amendment, you remember that we were trying to establish what is reasonable and what is not. And these exceptions, as you see, are very limited. So let's talk about some of these exceptions. After a little brief look at a news story, that goes without saying. All right, one of the exceptions is what they call the stop and frisk. And we've heard a little bit about stop and frisk in the news from time to time as a controversial method. But essentially, the courts have said, listen, it's okay for an officer if they stop you and talk with you and they are concerned that you might possibly have a weapon. It's okay for that officer to give you what they call a pat down. And a pat down is not a search. So they're not actually going into your pocket. They're just patting the outside of your pocket. However, during the course of a pat down, if they feel what feels like a firearm based upon their experience, they can go retrieve that instrument and hold it. So it's a concealed weapon. You don't have a permit and that sort of thing. They can actually go retrieve it. So the case that really covers this was what's called Terry versus Ohio, and you even hear it referred to as a Terry frisk. And what happened is the officer in that case saw a couple people casing a store. He thought that they may be looking to rob that store. He actually went and did one of these pat downs and actually did find a weapon and charged those individuals with a concealed weapon, and that created this case law. He was actually correct. They were probably to do that. Okay, moving on. The courts have also determined if we're going to take someone into custody, what we call search incident to arrest, it is okay to go ahead and make sure before we take them into our jail, they don't have anything on them that could create a problem. So you don't want somebody with a knife or a hand grenade in the jail. So they have said since you're taking custody and control of that person in a lawful arrest, we can go ahead and search that person, and not only the person, but their immediate area. So if we take him out of a car or that sort of thing, we can search that area where we took that person. So when you look at search warrants and warrant exceptions and that sort of thing, what the court is looking at too is we all have levels of expectations of privacy. And our home is probably the biggest level that there is. So the courts have said you have a big expectation of privacy in your home. We don't think the government should be able to put a bug in your house, for instance, to listen to your conversations without a warrant. They shouldn't just be able to walk in. But they have said with cars, well, there's a little bit less of an expectation of privacy because it's a mobile environment. You're on the roadways. There's a potential to cause more danger to other people. So Carroll versus the United States basically said that in certain cases, vehicles can be searched without a warrant if the officer has immediate probable cause to believe that there's some contraband in the car. Now, there's been some developments like Rodriguez versus United States and things of that nature since then, but essentially, there's a little bit less of an expectation of privacy with vehicles than there is homes. The Carroll case, and you can look that up if you'd like on your own, has to do with contraband related to alcohol and prohibition. Won't cover this too in depth, but it just makes sense that boats have a little bit less of an expectation of privacy too, as you may have seen in popular TV shows like The Deadliest Catch and such. The Coast Guard can board your vessel and do searches for verifying inspections of documents and that you're following codes. Only applicable to boats on waters, but you even see it in the state of Missouri, like in the Lake of the Ozarks. Now, this is not necessarily an exception, but it is something that you see used a lot. Certainly, a person can give up their rights. So, if the police department or a police officer talks to you and says, I would like to search your car, I just want to make sure that you don't have any guns, knives, or drugs, or hand grenades, or that sort of thing, you can certainly say, yeah, that's fine. I don't have a problem with that. And you can waive your rights. And essentially, a consent search, though, can be revoked. So if they go into your car and you say, I changed my mind, they have to actually stop. However, if you change your mind too late and they've already located some contraband, they're not going to stop, and most likely they'll get a search warrant. This makes sense too, doesn't it? It seems to be reasonable that if somebody is entering into the United States as a matter of a routine checkpoint, they can search your vehicle, and you have probably seen this on television too. And the same goes for entering other countries from the United States, so you can be checked entering Canada, for instance, for the same. An open field, essentially, you don't have much of an expectation of privacy, right? It's open. So you see this with regard to marijuana, sometimes cultivation, or some sort of illegal drug cultivation. You will see if a police department is in a helicopter overhead and they look down and they see this, that you don't have any expectation of privacy because essentially they have a right to that airspace. But even from the ground, if they can stand at your fence line and look out and see something bad like a meth lab set up in the middle of your field, well, that really can't be expected to be private. Plain view is the same thing too. So an officer pulls over a vehicle and looks into the car, and in plain view sees in the back of the car some sort of contraband, a kilo of cocaine or something like that. It's in plain view, and anyone walking by that car could see it. So there's really no expectation of privacy at all. They can actually go in there and seize that illegal contraband without a warrant. We have to keep our kids safe, right? So the Supreme Court has found that there's an exception to privacy within a school setting. So only public authorities really, though. So lockers and things of that nature, you will find police officers aren't going to bust into a locker, but the school authorities can, and they can certainly have an officer standing right there when they do it. Same kind of goes hand in hand with government offices. You're subject to search when you go into a government facility for safety reasons. This was probably accentuated a lot more after 9/11 or the Oklahoma City bombing. It's interesting, the correctional system, and some of you may have taken corrections classes in the past. Really, when you're on probation and parole, you are on what is called community corrections, and as opposed to institutional corrections. So the court has said, listen, you're going to continue to serve your sentence, or we're going to give you a sentence that you can actually live in public, but your rights are going to be reduced because you are actually still within the system, the correctional system. So in some people's cases, they will attach a provision to their probation or parole that they can be searched based or at certain times or anytime the probation officer wants to. So you'll see that from time to time. Drug testing. So again, if you refer to the protection of a person's person, when we talked about it earlier with the Fourth Amendment, we may have to seize their blood or urine for mandatory drug testing purposes. Don't run into this a lot, but we do it from time to time. The courts have said for the safety of the public, it's okay to do that. It's reasonable. This is a tough one, and you see this overused in some cases, so police officers really should use this sparingly, and so should crime scene investigators. What's called exigent circumstances. If you, for instance, go to a house and hear somebody inside yelling, "Help, he's killing me," the courts have determined that it is reasonable for that officer to go in to that dwelling in order to preserve life based upon what they hear. When they enter that house, whatever they see in plain view is acceptable to seize. The important thing is the intent here. The intent must be to preserve life and not to search for contraband. So that's the big deal with exigent circumstances. But again, exigent circumstances says if they have to make entry in order to preserve life, it's okay to do so. This is sort of like taking somebody into custody and taking them to jail in a search incident to arrest, but it kind of applies to vehicles. And it's not necessarily a search, it's just what's called an inventory. We're going to take control and care and custody of a vehicle and tow it. So, for instance, we pulled someone over, they have a suspended license, we're going to take them to jail for driving on a suspended license. We're taking control and custody of their car. We must be able to account for whatever's in that car. So if they go to the tow lot and say, hey, what happened to the $20,000 in our trunk? We'll be able to go back and say, well, hang on a minute. We did an inventory of your car, and there was not $20,000 in your trunk. So they have said it's acceptable to be able to do an inventory. Hot pursuit. This applies to somebody who has committed a felony crime. And if they run from the police and, for instance, they go into a house and slam the door, the courts have said it is reasonable if that person has committed a felony and there's probable cause to believe that they have, you can go ahead and go in after them. And again, whatever you see in and around that person or in that house is applicable to an exception to a search warrant. So let me go back. And they have a briefcase in their hand, and they put the briefcase down, and they walk away and leave it in a public street. They have abandoned their rights to that property. So abandoned property means like somebody throws something in the trash can, or they put it out to the trash, or they leave it in the street. They've abandoned their expectation of privacy to it. And again, this is a tricky one. You have to be real cautious, and the courts will interpret this based upon what they think the expectation of privacy is. But this applies to what they call abandoned property exceptions. In some cases, too, so we go back to the exigent circumstances. This is somewhat related to that, too. In some cases, so I'll give you an example. Officers go to a house that they have information that there could be a meth lab going on inside of the house. They hear the breaking of glassware when they get there, the flushing of toilets, and they smell things that smells like chemicals used in a meth lab, and the people won't answer the door. The courts have said, listen, in certain cases, we think it is reasonable for you to make entry to preserve the destruction of evidence. If you can really articulate that you think evidence was being destroyed, it's okay to do so. Again, articulation is the key. And this one is one that you never use intentionally, but sometimes occurs. It's called inevitable discovery. So sometimes the courts have found that essentially they think the investigators would have found this piece of evidence at some point in the investigation anyway. So maybe they didn't follow the steps to the T. Maybe things weren't 100% correct, but they find some evidence, and the court said, well, they probably would have anyway. We're not going to toss it out. So going back to the exclusionary rule, this is sort of a way sometimes that has been discarded in certain cases. Again, it's never one that the police should enter into voluntarily and say, we're just relying on inevitable discovery. It's one that each individual court has kind of applied to certain cases that they just feel this would have happened. Another very important thing to remember is that search and seizure law is constantly changing. As I talked about, there have been cases in the last year or two that have really changed search and seizure, and there probably will continue to be, particularly with regard to things like electronic media that we're experiencing more and more today dealing with. So it's something that is never set in stone. We always have to pay attention to. So it is just remember that, and that may be important for exam purposes too. Search and seizure law is not set in stone.